Audio test 1 for the meeting stream. Audio test 2 for the meeting stream. Audio test for the meeting stream.
Mr. Pello, it's 2 o'clock now, and I believe all the committee members who are going to take part today are present. Are we ready to begin?
Chair, we can begin. Chair, we can begin when you're ready.
Eric or Melanie, I don't know if one of you can hear me. I just want to confirm if we're ready to begin.
Sorry, Chair. Melanie was responding
I
that
seem to
yes,
be
you
having
can
an audio
proceed
output issue here.
at your convenience.
Okay, sorry. Could we try that again?
Mr. Chair, can you hear me?
I can hear you. Yes, thank you.
Okay, I think the audio is sorted out.
Okay. Are we ready to begin then? Apologies there.
Yes, Chair, no problem to proceed.
Okay, thank you very much. Okay, good afternoon. I'm going to call the September 9th, 2025 meeting of the Election Compliance Audit Committee to order. We'll dispense with calling the roll, but I will note for the record that Member McGoldrick and Member Bergeron are not present and are not taking part in today's meeting. So we will move to item 2 on the agenda and whether there are any declarations of interest.
No.
Seeing none, we'll move to item 3 and the confirmation of the minutes of the April 24th, 2025 meeting of the Election Compliance Audit Committee. Members, are those minutes confirmed?
Confirmed.
Confirmed.
Thank you. Before considering the substantive item on today's agenda, I would like to clarify the committee's purpose and process today. With respect to item 4.1, the committee will be considering the report from the auditor appointed by this committee with respect to apparent contraventions of the Municipal Elections Act 1996, and will decide whether to commence a legal proceeding against the candidate for any apparent contraventions. This committee, the auditor, and the city clerk do not have any power to determine whether a contravention of the act has occurred. In that regard, a decision by this committee that legal proceedings should be commenced does not mean that a contravention has occurred. That determination is within the Court of Ontario's jurisdiction. If the committee decides to commence legal proceedings, the matter will be referred to an independent prosecutor who will retain his or her own prosecutorial discretion as to whether or not to move forward with a prosecution. With respect to the process today, this committee is not a court or a quasi-judicial tribunal. The hearing is inquisitorial, not adversarial in nature. There is no cross-examination contemplated by our rules of procedure, and there will not be any cross-examination of any participant. The committee may hear from the parties and/or representatives of the parties. Each party and the representative have a combined 10 minutes to speak. The committee's rules of procedure do not allow for a right of reply from any of the speakers and does not allow for debate between the applicant, the candidate, or the auditor. Committee members may ask questions of the speakers for the purpose of obtaining information or receiving clarification on the matter under discussion. Once all the speakers have spoken, committee members will have an opportunity to ask questions of the auditor, city staff, or the committee's legal counsel, as well as an opportunity to speak on the matter. The committee will then adjourn the meeting to deliberate in private and decide the matter or render a decision immediately after all representations have been made. With that, we will move to item 4.1 and the consideration of the auditor's report for the election compliance audit of the campaign finances of candidate Sean Menard, Ward 17 Capital from the 2022 municipal elections. And I'd like to invite those present from the auditors, Oxaro, to provide an overview of their report.
Perfect. Thank you very much. Yes, so we were engaged to provide a compliance report relating to the election campaign finances for the 2022 regular election campaign for candidate Sean Menard. Our procedures related to the complaint made in the application for the compliance audit and also other provisions within the Act relating to campaign finances, those being sections 88.8 through 88.32. Please reference our report procedures, observations, and conclusions, and I'll summarize our reports and findings right now. So I will start with the complaint. The complaint related to the quantity and value of the signs and materials used from a previous election. Based on our procedures, we found that there was an apparent non-compliance. I'll go through some of our observations. The candidate reported in their financial statements using the following goods and materials from the previous campaign: 600 H-frames, 250 small signs, and an amount of $100 for sign materials. We obtained invoices from the candidate's sign vendor for the 2018 campaign and the 2022 campaign. The vendor searched the records but was only able to provide one invoice for the 2018 campaign. The candidate and other campaign members confirmed that the candidate was the only individual involved in the counting or inventorying of the signs and sign material from the previous campaign. The candidate confirmed that they had made an error in reporting their previous signs. He indicated that he should have reported 10 large signs being used from the previous campaign. The candidate also noted that he was able to salvage 250 signs from his previous campaign, and that is what he reported on the financial statement. But he noted he was only able to use 200 small signs from the previous campaign. The candidate confirmed he used $100 for sign materials as an estimate or a catch-all. Based on our procedures, we assessed and recalculated the amount reported for signs and sign materials. Based on our recalculations, we concluded that the candidate underreported the amount for signs used from the previous campaign by $310.98. This was driven by the error in not reporting 10 large signs, which had a higher cost than the small signs reported. Therefore, the amount reported was inaccurate and an apparent non-compliance of Section 88.193 of the MEA. We concluded that the estimate recorded in the financial statements for the previous campaign sign materials was deemed to be reasonable. Accounting for the understatement in the signs did not place the candidate above the spending limit per the MEA. Based on our other procedures performed, we did not find any other inaccuracies within the campaign financial statements, and all support was provided during our engagement from the candidate. Again, please refer to our report for additional details, and thank you very much.
Thank you very much. Members, I'll invite those of you who may have questions for the auditor now, if you wish to ask any, and there'll be a further opportunity after we hear all remaining submissions to ask the auditor any other questions. But do the members have any questions for the auditor at this time?
Not at this time, but potentially after hearing the rest of the submissions.
Thank you.
None at this time, Chair.
Thank you very much. Okay, then at this time we will move. Is I understanding correctly that Mr. Pappas is here on behalf of the applicant, Mr. Phillips?
Yes, good afternoon, Mr. Chair.
Thank you very much. Mr. Pappas, you have 10 minutes for any submissions that you may wish to make.
Great. Thank you, Mr. Chair, and good afternoon, members of the committee. I trust you have a copy of my written submissions that I've filed with the city and have had an opportunity to review those, and I'd like to supplement those with oral submissions that will highlight the salient points that the applicant, Mr. Phillips, would like to make. it's the applicant's respectful submission that this committee should authorize a legal proceeding against the candidate for the reasons set out in our written submissions. I'd like to cover three important points from those written submissions, but before I get there, I'd like to start with some important context to frame this discussion. Here, we're not dealing with a neophyte or a newcomer to municipal politics. We're dealing with an incumbent candidate who has experience running in multiple municipal elections. And with this experience, the public would have higher expectations on a candidate. But instead of greater familiarity with the campaign finance rules, the participation in past elections has actually given rise to the issue at hand here. And you've heard from the auditor, Oxaro, that the issue at hand is failing to report the value of reused election signs from a past election. The reason why we say a prosecution is warranted in this context is that an advantage the candidate had as an incumbent and as an experienced candidate over others was hidden from public scrutiny. And that's contrary to the public interest principles that underpin the MEA. The first point I want to make for the members of the committee discusses the nature of the contraventions at issue. And I say contraventions plural because looking at this from a prosecutorial lens, there may well be multiple offenses of the act and why those are significant. So the findings set out in the report in my submission set out three distinct areas of noncompliance. First is that the candidate failed to accurately report his campaign expenses. And this is noted in the report, and you've just heard from the auditors. Subsection 88.19(3) of the MEA provides that the replacement value of goods reused from a previous election are a campaign expense. And the candidate failed to include the replacement value of 10 reused large format election signs in his financial statement. That is contrary to the MEA, and that is a discrete offense under section 92 sub 1 clause B of the MEA. And second, this finding also has an inverse side because a financial statement is a ledger. What comes in must go out. What this finding also means is that the candidate failed to accurately report contributions to his campaign, and specifically contributions that the candidate made to his own campaign. Under section 88.15 of the MEA, the fair market value of goods that are contributed to a campaign in kind are deemed to be contributions. And this is also made clear in the structure of the prescribed form of financials and boxes within the contribution schedule dealing with materials reused from a previous election, and those are contributions. Again, the candidate did not include the value of those 10 reused large format signs, contrary to the MEA. And the third issue that I'd highlight, I've dealt with this in my written submissions at paragraph 15 through 17, but I also like to highlight this. There's an issue which in my submission, the report overlooked or did not identify and could form the basis of an additional charge that a prosecutor may wish to lay. And that's the failure to ensure that contributions of goods are valued. That obligation arises under a candidate's general obligations under section 88.22 sub 1 of the MEA. And that sets out a number of record-keeping obligations that aim to assist in preparing an accurate financial statement. And the findings of the report indicate that the candidate did not take steps to ascribe value to the 10 reused large format election signs, contrary to his obligations under the MEA. So we're dealing with three issues that arise from one transaction or one area of default. The second point I want to make is why these issues are significant enough to warrant a prosecution. And that's because they strike at two basic principles that underlie the MEA. Those are transparency and fairness. Now, as to transparency, in a case that I've included in my written submissions, Giannini in Toronto, Justice Dunphy, in walking through the regime and understanding how the various components fit together, notes that the mandatory reporting requirements of the campaign finance regime permit public scrutiny of campaign finances. And that is what in turn promotes public confidence in the electoral process. A financial statement needs to be correct and accurate, and failing to do so is an offense. The second principle is fairness, basic fairness, but more specifically, fairness between candidates. In another case that I've included in my written submissions, Braden, Georgian Bay, Justice Wood highlights that one of the basic principles that underlie the campaign finance rules is that all candidates must be placed on a level playing field relative to one another. And in this specific context, that is why the MEA imposes rules on candidates who reuse campaign materials from a past election. They've already spent the money to obtain those goods or services, and where they reuse them, they don't have to spend money in the present day, whereas other newcomers to the process may have to. And that's why, as identified by the auditor, Section 88.19 sub 3 provides that the replacement value, not the value of the purchase of those goods at first instance, but the replacement value, the current market value of those goods, must be included in a candidate's financial statements. The issues arising from the report indicate that the candidate had an advantage over other candidates because of these pre-existing campaign materials, and the fact that they were used in the campaign was hidden from public scrutiny. They were not reported in the financial statement, and this threatens to hamper public confidence in the electoral process. That is the real issue that is before the committee. What the candidate may say in response is that, and following along something that the auditor had mentioned in the report and in their presentation to the committee, is that even with these adjustments, the candidate still did not exceed the spending limit applicable to this particular race and did not exceed the contribution limit to his own campaign. And in my submission, that's the wrong focus. If that's the only thing that mattered, whether a spending limit was adhered to or whether a contribution limit was adhered to, the MEA wouldn't impose a series of intricate financial regulations that are all backed by an offense provision and a penalty provision. It would only have maximum limits. And in this sense, that's what goes to protecting the public interest considerations of transparency and fairness. And second, what the candidate may also indicate is that the dollar value at issue here is in the quote unquote de minimis range, which would warrant not commencing a prosecution. And in my submission, that's wrong too. As this candidate or this committee has previously observed with respect to an earlier report regarding the third-party advertiser Horizon Ottawa, this determination, so the de minimis determination, is bound up with the extent to which the public interest considerations that underpin the campaign finance rules are also transgressed. It's not just the dollar value. And as I've mentioned, those principles of transparency and fairness were violated because an advantage that the candidate had was hidden from public scrutiny. And the last point I wish to make to the committee is that this committee in earlier terms or in previous terms has determined that it's appropriate to move forward with legal proceedings against current public office holders for similar issues. In 2022, in respect of the 2018 municipal election, this committee, differently constituted, decided to commence a legal proceeding against Councillor Laura Dudas. And the issues in those circumstances were the same as the ones that we were dealing with here. Reusing campaign materials from a previous election without appropriate reportings in a financial statement. And in an earlier term, in 2015, in respect of the 2014 municipal election, the committee also decided to authorize a legal proceeding against Councillor Mark Taylor. And this was despite the auditor commenting that the failure to carry over a deficit from a previous election into the current election and financial statement was a, quote, clerical error. The committee still referred the matter to a prosecutor because in one of the members of the committee's view or statement at the time, it was still an error that could simply not be overlooked by the committee. And in my submission, those are the same considerations that should factor into the committee's decision with respect to this matter. In closing, members of the committee, it's my submission on behalf of the applicant that the committee should authorize a legal proceeding against the candidate in these circumstances. The reason why is because the public policy principles and the public's expectation of how those principles are to be adhered to were not followed in the circumstance. The candidate had an advantage by virtue of being an incumbent, and this was hidden from public scrutiny because the candidate failed to make appropriate reportings in his financial statement. Subject to any questions, those are my submissions to the committee.
Thank you very much, Mr. Pappas. Member Eldhar, Member Bassett, do you have any questions for Mr. Pappas?
I do have one question. Mr. Pappas, you're alleging a number of contraventions that are not in the auditor report. Are you indicating that the auditor report is deficient? Or is that your indication here, just for clarity purposes?
So that's a fantastic question, Member Eldar. My submission is that the committee needs to consider how a prosecutor might look at this matter as well. The report forms the sort of factual underpinning, if you will. But if this is referred to a prosecutor will have to distill all this to a number of charges in an information. And my identification of three matters, in my own experience working in this field, there could be three discrete charges laid against this candidate based on the information that's summarized in the report.
Okay, thank you.
Any further questions, Member Bassett or Member Eldar?
No questions.
Mr. Pappas, I just want to clarify or probe further one of your final comments with respect to, you use the word advantage. I just want a better understanding. The failure to report or inaccurate reporting on the Form 4, again, indicates an apparent contravention of the MEA. But I'm having some difficulty understanding to what extent that then creates an advantage for the candidate when there hasn't been any exceeding of the spending limitation amount. But for whether we call it a clerical error or bad arithmetic, bad estimating, whatever you want to chalk it up to, what is the advantage of having made the sort of administrative error?
Thank you, Chair Cullen. The advantage that an incumbent candidate or a previous, we'll call it incumbent candidate, someone who's run before, they did not have to spend money in the present election to obtain the benefit of some good that is being reused. And I've mentioned how the regime deals with this. You have to take the replacement value costs, but that is truly the advantage. The candidate did not have to spend money in not present day, we're not talking about 2025, but in the 2022 election to obtain the advantage of signs that he'd previously purchased, whereas a newcomer to the election would have had to do so. That advantage was something that wasn't reported in the financial statement, and the public was deprived an opportunity to scrutinize that.
So the advantage, as I understand that, is the reuse of the signs. Because I guess what I'm struggling to agree with or accept completely is I would see it being an advantage if they, circumvented the spending threshold, but they're free to use signs over again, provided they valued them appropriately. They either weren't valued properly or weren't reported properly, but the advantage you're speaking of is merely the fact that they have previous campaign materials that can be put to use again.
That's correct, without having to spend funds in the present day and incur present day expenses, if you will. And that advantage has to be reported at the end of the day.
Okay. Thank you. Any other questions from the committee? All right. Thank you very much, Mr. Pappas.
Thank you.
We'll move now to the designated person, then candidate Mr. Sean Menard. Mr. Menard, you have 10 minutes for any submissions that you'd like to make to the committee.
Thank you very much, Chair. I appreciate you allowing me to address the committee today. I won't take up my full time. I only have a few points to speak to today. The comprehensive audit in front of you speaks for itself. I respect its findings. It's consistent with what I've previously discussed with this committee. The audit itself was time intensive, with every single transaction, donation, receipt from the campaign produced and balanced. There has been extensive reporting on this issue, both over several years now, both through city reports, mainstream media, and social media. And perhaps most relevant, Chair, and most importantly, the public interest in the judicial decision ordering the audit. Justice McLeod held that small irregularities may be indicative of more significant irregularities, which is why he felt the audit was appropriate, that there could be or may be other significant irregularities there. With no significant irregularities found in this case, it's my contention that there is no public interest in taking this further. I'm happy to present myself to today, answer any questions you may have. And as I say off the top, I respect the outcome and the findings of the comprehensive audit.
Thank you very much, Mr. Bernard. Member Eldar, Member Bassett, do you have any questions for Mr. Bernard?
None, Mr. Chair, no.
Thank you. Mr. Bernard, I don't believe the committee has any questions for you today. Thank you for your comments.
Thank you, Chair.
Members of the committee, having heard from the presentations of Mr. Pappas and Mr. Bernard, do you have any other questions for the auditor?
I have one question for the auditor, actually. Mr. Pappas provided a number of additional comments. Do you have any sort of determination, or have you found any evidence to support his comments, or to refute them for that matter?
Again, our report is based on, the procedures that we thought were necessary to, test the compliance, and we still feel that our report is accurate and displays the results of our audit. So,
thank you.
Member Bassett?
I do have a question, please, for the auditors. In the statement, there was questions as to why the auditors did not speak with the applicant. Can you address that, please?
yeah, again, we have the application and we had all the information from the application, and then we determined our procedures not to require that, and we had, presented our procedures to the city and agreed upon the procedures to be performed. So we do not determine that that was a requirement to assess the compliance with the sections of the Act.
Thank you, Mr. Chair.
Thank you. And I just have one question with respect to the requirement in your report in section 4.1.2 refers to the MEA and then the candidates guide that indicates it's requirement for the candidates to establish the current market value of reused goods, the cost to purchase them today. And when I turn then to I'm not sure what internal page is this, 16 of your report, and the assessment of the quantity and current market value of the signed material. Based on your interview with the candidate or the form, he noted that $100 was used as an estimate for the signed material. And while your own valuation determined that that estimate was reasonable, I guess I want to understand in the course of the conversation that you had with the candidate, did it become clear how the candidate derived that estimate, and did they actually do anything to establish the current market value of the goods in a fashion similar to the calculation that you performed as auditors, or was it sort of a guesstimate, for lack of a better term?
Again, I don't think I think there's a section in there where it's based on, the large signs that were used and kind of an estimate based on that as to the wooden stakes that would be required and the zip ties and the screws and stuff like that. So again, that's kind of how it was established by the candidate to determine that estimate.
I guess to clarify, the independent calculation that was undertaken by XRO involved, I presume, either contacting Holly Sign or purchasing items or investigating the cost to purchase items. And to your knowledge, did the candidate undertake a similar exercise in order to arrive at their estimated cost for wooden stakes and zip ties, or did they just arrive at a number based on some mental math in their own head? I'm just wondering to what extent your interview with them identified how they went about determining and assigning a current market value of the goods.
I'm happy to jump in for that one.
Sure.
Just through discussions with the candidate. So we had a general conversation more around the total dollar or total quantities that were required, and then an assessment of the need for additional. We did not go in depth about the recalculation value. We spoke about, a general value that was acquired. It was the $22 that was acquired for the current year's value. And then we used the quantities that were obtained in order to do the recalculation.
Thank you. Any further questions from members of the committee? Members, do you have any questions for city staff or committee council, or do you wish to make any comments on this matter in the open session of the meeting?
None, Mr. Chair, no.
Thank you. All right, then the committee is now going to adjourn and deliberate in private on this matter pursuant to subsection 88.33 sub 5.1 of the Municipal Elections Act, and we will reconvene thereafter. Thank you. James or Melanie, the email from James attaching the text of the decision has been held up. Oh, never mind. I've just got it. Finally, it's come through. For some reason, my emails from James take a little while to get through the spam filter.
I'll try not to be offended by that.
Okay, I believe we're all present. Melanie, are we good to begin again?
Yes, Chair, you can begin.
Okay, thank you. The committee will now reconvene and I will move the decision motion. In the matter of candidate Sean Menard, I move that it be resolved the committee issues the following decisions and reasons. Upon receiving the report titled Auditor's Report Election Compliance Audit of the Campaign Finances of candidate Sean Menard, Ward 17 Capital from the 2022 municipal elections, the report, and upon hearing the representations and/or reading the written submissions and documents submitted by the auditor, the candidate, and the applicant's representative, this committee hereby decides not to commence legal proceedings against candidate Sean Menard for apparent contraventions of the election campaign finance provisions under the Municipal Elections Act, 1996. The committee considered the auditor's report, which concluded as follows. 1. There does not appear to be an apparent noncompliance with paragraph 88.22 sub 1 sub D and subsection 88.25 sub 3 of the MEA. 2. There is an apparent noncompliance with section 88.19 sub 3 of the MEA. And 3. There does not appear to be an apparent noncompliance with paragraphs 88.22 sub 1 sub G and sub H of the MEA. With respect to the apparent violation, the report stated that the amount recorded in the financial statement for the election campaign signs reused from the previous municipal election was inaccurate. Specifically, the auditor found Mr. Menard understated the sign expenses by $310.98. The report also noted that in his Form 4 financial statement, Mr. Menard estimated the cost of sign material used in the previous election to be $100. The auditor considered this estimate reasonable based on its own research showing the subject materials would have cost $98.12 if procured based on prices listed by a reputable hardware supplier. The auditor noted that the apparent violation it identified does not place the candidate above the MEA's spending limit. The committee considered the written and oral submissions of the applicant, Edward Phillips, by his representative, Mr. John Pappas. In summary, Mr. Pappas argued that Mr. Menard, with his prior experience from multiple elections, failed to accurately report the replacement value of reused campaign materials, specifically large election signs, in his Form 4 financial statement. This caused him to understate both campaign expenses and in-kind contributions, which contravened the MEA. This breach, Mr. Pappas contended, was no mere clerical oversight, but a fundamental threat to the MEA's core objectives of transparency, accountability, and fairness. He also submitted that even clerical errors may give rise to a decision to refer a matter to prosecution under the MEA. For this proposition, he relied in part on a previous composition of this committee's decisions in matters involving Laura Dudas and Mark Taylor. He also referenced the committee's previous decision regarding Horizon Ottawa. The applicant's submissions also criticized the auditor for not consulting him despite his ability to provide purportedly relevant evidence. Mr. Pappas cited the MEA's policy goals and referenced case law such as French and Township of Springwater 2018 ONSC 94, which described the committee's role as a gatekeeper assessing public interest. On the de minimis doctrine, Mr. Pappas drew from Jackson and Vaughan City 2009 59 MPLR 455, arguing that even small dollar amounts may be a relevant consideration for the committee's role at this juncture. Mr. Pappas also stated that this committee has made decisions to commence legal proceedings in the past. For example, on March 10, 2020, the committee voted to initiate proceedings against Laura Dudas after an external audit identified areas of noncompliance in her election finances, including the improper reporting of reused campaign materials from a prior election. Similarly, On December 14, 2015, the committee decided to commence legal proceedings against Mark Taylor for a clerical error in his 2014 election financial statement related to inaccurately reporting a carried over campaign deficit. In its decision, the committee noted that errors, regardless of intent or scale, should not be overlooked. In oral submissions, Mr. Pappas encouraged the committee to consider the issue from the perspective of the prosecutor, noting that the one act or omission at issue in this case gives rise to several discrete violations of the MEA. Mr. Menard indicated that he respected the auditor's findings and noted that they are consistent with what he previously stated to this committee. He stated that the audit was time-intensive. He complied in producing all receipts and records of expenses and contributions in his possession related to his campaign. He likewise noted that this matter has received extensive media coverage, both mainstream and on social media. Mr. Menard submitted that in the appeal from the committee's previous decision at the application stage of this matter, Regional Senior Justice McLeod observed that small irregularities may be indicative of bigger ones that may only come to light after a compliance audit. This was one of the bases for allowing Mr. Phillips' appeal and directing this committee to order a compliance audit. However, now that the audit has been completed, no further apparent violations were found. He summed up his submission in stating that in the circumstances, the public interest would not be best served by referring this matter to prosecution. The committee agrees with the auditor's statement that there is an apparent violation of subsection 88.19 sub 3 of the MEA. The auditor's report stated that the amount recorded in the financial statement for the previous election campaign signs was inaccurate and is in apparent noncompliance of subsection 88.19 sub 3 of the MEA. The committee sees no reason to doubt the correctness of the auditor's conclusion on this point. The committee likewise agrees with the auditor that, accounting for the understatement relating to signs, Mr. Menard remains within the spending limit per the MEA. The committee also notes that Mr. Menard did not exceed the maximum contributions allowed from a candidate or his or her spouse. This is even when one accounts for the understatement of the sign values giving rise to the apparent violation at issue. Concerning the submissions by Mr. Pappas, the committee finds that all candidates are subject to the same regulatory requirements under the MEA and should be subject to the same level of scrutiny and accountability, regardless of whether they are first-time or seasoned candidates. To the extent the applicant's submissions suggest Mr. Menard as a repeat candidate should be held to a different standard, the committee rejects that submission. The committee has reviewed and considered the relevant case law and the prior decisions of this committee referenced in Mr. Pappas's materials. The Dudas decision is distinguishable, as there were, quote, a number of apparent contraventions, end quote, which the committee considered, quote, too numerous, end quote, to forego referring the matter to prosecution. With respect to the Taylor matter, it is true that one member of the committee commented that, quote, clerical errors are still errors and minor errors can't simply be overlooked, end quote. Respectfully, despite this absolute statement, the case law is clear that at this stage of the committee's proceedings, the committee retains discretion not to refer a matter to prosecution if it considers the apparent violations de minimis. Concerning the submissions made by Mr. Phillips about a clerical error in Phillips and Ottawa Elections Compliant Audits Committee, the Superior Court stated that an error that is not a mere typographical error, but is a substantive inaccuracy in calculation or reporting is sufficient to clear the very low hurdle at the first step of the Section 88.33 procedure. This suggests that there are certain types of typographical, clerical, or trivial errors that are so minor that they do not even contravene the MEA to begin with. One example would be the errors that candidate Harris made in Lancaster and Compliance Audit Committee 2012 ONSC 5629, where a candidate accidentally listed 2 associated corporate donors under Table 2 of Form 4, but had accurate information otherwise. The court found no violation of the MEA. As such, at this final stage of the committee's procedure and in line with the case law, there is discretion not to refer a matter to prosecution in the face of an apparent violation. If the committee considers it insufficient to merit that step. In the particular circumstances before us, the committee considers the apparent violation to be de minimis and that commencing legal proceedings is not warranted. First, Mr. Menard has accepted the audit report demonstrating accountability. The identified issue pertains to the reuse of campaign materials, which resulted in a discrepancy in reported expenses. The audit confirmed that Mr. Menard's campaign did not suffer from systemic or intentional violations. Second, the committee considers the apparent violation de minimis based on the following circumstances taken together. One, the dollar amount, $310.98, is fairly low. Two, the underreporting did not result in Mr. Menard exceeding his expense limits. Three, Mr. Menard did not exceed the maximum contribution limit for a candidate and/or spouse. And four, the committee does not find that Mr. Menard gained an unfair advantage due to the apparent violation. Third, from a transparency and accountability perspective, Mr. Menard's campaign finances have been heavily scrutinized, both in this process and the media. Although this factor on its own would not cause the committee to abstain from commencing legal proceedings, when considered together with the previous points, the committee is of the view that the MEA's transparency and accountability objective has been served. Had Mr. Menard's violations been of a sort that could, in the eyes of a reasonable member of the public, resulted in an unfair advantage, or one that might impact the integrity of the election process, our decision might have been different. This is not the case. In the result, the committee is driven to the conclusion that weighing these factors, the public interest is best served by not commencing legal proceedings in these circumstances. Members of the committee, is the motion carried?
Yes.
Yes.
And as there are no dissents, the motion is carried. Turning to item 5 in the agenda of today's meeting, are there any inquiries? Seeing none, under item 6, is there any other business? Seeing none, then we move to item 7, adjournment, and this meeting is adjourned. Thank you, everyone.